Welcome. Welcome to A Taste of Justice. I am Professor Angela Mae Kupenda, a professor at Mississippi College School of Law. But I tell you that only for identification purposes. Our views or nuances or interpretations here are my own and are not to be ascribed to my school or to my students. I've got some exciting news for you. So as you know, this semester we're doing two series in one, A Taste of Justice, one with principles from my constitutional law course, and the other with principles from my civil rights lawsuits course. Okay, now the goal is, of course, to give my students who are taking my courses remotely just a little something extra, and also for all of us to give us more learning about the Constitution, to move us toward more knowledge about the Constitution, and hopefully toward justice, or at least a taste of justice. Now, in just a few weeks, my students in my con law course will be writing and presenting in my class position statements on current constitutional conflicts, all the things that people are fighting about right now about the Constitution. They will prepare position statements and present them in class. Now, I'm not requiring them to post those on YouTube this time, but each class meeting, as they discuss them, I will make sure I make good notes. And when I come to you with a video clip, I'll share with you what the future lawyers are saying about some of these current constitutional conflicts and the disagreements we have in the classroom about how they should be resolved. That will be coming in a few weeks. Now, today, I want to shift gears a bit. We're going to talk about the national government and the three co-equal branches of the national government. Now, there are so many topics in con law that we're covering in class, but I can't do videos on all of those for you. So here, I'm just trying to give you a taste of those topics, and make sure you look at the notes below the clip, and you can see things you can go and read to learn more. And maybe next fall, when I hope to teach constitutional law again, I will add some clips on the topics that we haven't discussed. Okay, now, our national government. Our national government, well, let me go back. The national constitution, that's what we're referring to. You know, each state also has its own constitution. The national constitution was designed to create and limit the national or the federal government. The Constitution created three co-equal branches of the government. We have the judiciary and the courts, or the judiciary, the federal courts. Their assignment, so to speak, is to interpret the laws and interpret the Constitution. We have Congress, the House of Representatives, and the Senate. Their job is to, you know the answer, to make the laws. And we have the office of president. The executive's job is to execute the laws. So we have these three branches, and the court has said that they are all equal. They are co-equal. But depending on the situation, one may have more authority than the other. Now, you probably have some co-equal relationships or some co-equal friendships. You know how that goes. There may be a lot of tension sometimes as one or the other wants to have the last word, the final word, the most powerful word on a particular matter. So the same thing with these three co-equal branches, there can be, and usually there is, a bit of tension and a bit of battle for power. Now, we know that the Congress is elected, the members of Congress are elected by the majority in their particular states. We know that the president is elected theoretically by the majority. But with this thing with the Electoral College, it is indeed possible that a president may not receive a majority of the vote and still have the majority of the Electoral College and is able to become president. And so we have Congress elected by the president, Congress elected by the majority. We have the president elected theoretically by the majority. And we also have our state governments, which also, at least theoretically, are elected by the majority in those states. So you may say, with all of this majority rule, what about the rule? What about the rights of those who do not fit into whatever majority group we're referring to, whether it is a majority group related to religion or majority group related to orientation, majority of power with gender, majority related to race, or what have you. So in the past, non-majorities have counted on the court. The judges serve in good behavior. They serve for life when they serve in good behavior. They may not be in good behavior. We know that at least the Constitution provides for an impeachment process, but it's rare that a federal judge is indeed impeached. But we have the court, and it's thought that the court represents independent judgment. It's an appointment for life, and they would uphold principles of the Constitution even for minorities. There is this quote that says the majority can trample the rights of the minority. So we've seen this in some cases, and we've seen the court in instances protect minority interests, like in Brown versus Board of Education, and some other cases I've mentioned in the notes below, as I always do, so you can go and read more for yourself. So, in addition, minorities count on their own civil rights movements to prick the consciences of the majority so we can move toward more justice. Now, so we have this framework going back to the national government. We have this framework where we have three co-equal branches. And so today I'm going to do two clips for you. One is going to be on the power of the federal court. And then the second clip is going to be on limitations of that power. So let's look at the power of the federal court, the U.S. Supreme Court and other courts. What power does the court have? Now we know the court does not have the pocketbook. Congress has the pocketbook, so to speak. We know the court is not in charge of the military. The president is the commander-in-chief of the military, even if the president has not actually served in the military. So what power does the court have? The court's power is called the power of judicial review. So when other co-equal branches, or when the states, or just when people do things that may be unconstitutional, the court has the power of judicial review, meaning you get to act, the president gets to act, Congress gets to pass legislation, but the court says it has the authority of judicial review to tell them whether or not what they did was indeed constitutional or unconstitutional. Now, where does this power come from? I mean, when you're looking at the power of the co-equal branches, it is indeed about the structure of our Constitution. Some have said our Constitution is a finely wrought instrument. It is a system of checks and balances. And someone else, and I tried to see who the quote could be ascribed to, but there were so many who were mentioned. But there's this quote about power, and it's something like power corrupts and absolute power corrupts absolutely, something like that. So our Constitution seeks to avoid that absolute corruption by having the system of checks and balances. Back again to the court. Now, where does this power of judicial review come from? Well, we're going to go all the way back, even before I was born. We're going to go back to a case from 1801 called Marbury versus Madison. Now, this case is very difficult to read, but I gave you the years so you can look it up and read it for yourself. But it has some very interesting language in it. And it is indeed a case about power. Here, the court decided to lose the fight to win the battle. Now, that's something else. So let me tell you about it. And I have my notes here so I can keep all of the party names straight. It reads like the great drama that it was. So what happened, it all started in 1801 when President John Adams was the outgoing president. Not only was his party losing the office of president, his party was also losing control of Congress. And so it said, wait a minute, our party is losing control of the presidency. We're losing control of Congress. We got to have control of something. So his party said, we're going to try to maintain more control of the courts. So what President Adams did before he left office, he issued some more judicial commissions to appoint some more judges. And these commissions were supposed to be delivered. His Secretary of State was John Marshall. Now, Marshall was at least in a supervisory role to make sure that these commissions got delivered, but all of them did not get delivered. And Marshall had been appointed by the president, the outgoing president, to become Chief Justice of the Supreme Court. The outgoing president was trying to make sure that best he could, that he had control of the courts. So all of the commissions did not get delivered. The new president came in, Thomas Jefferson, and there were the commissions still there in the office. And President Jefferson told his Secretary of State, James Madison, don't deliver them. They didn't deliver them before they left office, so they are of no effect. Do not deliver them. But Marbury, remember, he was waiting on his commission. He had been appointed a judge by the outgoing president. He said, I want my commission. I'm entitled to be a judge. So Marbury said, give me my commission. And the new president said, no, we're not. So Marbury filed suit. Now, when he filed suit, and it was going to be in the federal court and ultimately in the Supreme Court, it was under a law that Congress had passed that would give the court that jurisdiction. And that's an important point for later. So what Marbury did is he issued, don't you see how excited I am talking about all of this power? So what Marbury did, he sought to mandamus the president. Now, a mandamus is an extraordinary type of writ. It's one thing to tell a person, if you do that, you pay me damages. Well, the mandamus doesn't do that. A mandamus says, you must do this. So here we have Marbury issuing, seeking to obtain a mandamus against the president to force the president to give him his commission. Isn't this something? And we're talking about back in the 1800s. We're not talking about politics right now. We're talking about what happened in 1800. Okay? So now remember, the new Chief Justice of the Supreme Court is John Marshall. He is the one that was supposed to deliver the commission, or at least he had supervisory authority. And so now here's the case, mandamus the president. You would think that Marshall would have said, oh my, I have to recuse myself from this. I was involved on the other side. You would think that's what he would have done, but he didn't do that. Instead, Marshall not only participated in the deliberations, Marshall wrote the opinion himself. So he's writing this opinion about something he arguably was part of the mess up, where Marbury attempts to force the new president to deliver the commission to him. Now, this opinion by Marshall, whether you agree or disagree, it's brilliant. This is what he says, and I'm going to paraphrase. I've indicated in the notes how you can find it on Google. You can read it for yourself. But here it is amazing. This is what he says. He said, Mr. President, the court has the power of judicial review. One of the branches has to have the final word. And it makes sense that on matters as to what is constitutional or not, that should be given to the court. He goes on to say, Mr. President, you're not a king. The United States is a country of laws. It's not a country of men. In other words, he said, when another branch, like the presidency or Congress, is involved, he said, of course, I'm going to be delicate with you. And of course, we have to be cautious with how we relate to one another because we are co-equal branches. He said, but I'm here to tell you, Mr. President, that the court has the authority to tell you when you are acting unconstitutionally. Isn't that something? Okay, but he didn't stop there. He said that the law that gave Marbury, that gave the court jurisdiction to hear this, the law by Congress, was an unconstitutional law. And the court is determining it is. And so therefore, he cannot issue Marbury the relief that he requests. So in other words, he lost the fight. He gave up the fight. Marbury would not get the commission, but he won the battle in the sense he articulated for the court this power of judicial review, this power to check the other co-equal branches when they act unconstitutionally. Isn't that something? Are you as excited about this as I am? Now, later on, the court said that it also had the power to tell Congress when they're acting unconstitutionally. The court also said that if a state court gets something wrong on a constitutional matter, they will straighten out the state court to the state Supreme Court. And the court ultimately said, even if the state governors are acting in an unconstitutional way, they will also check them. And we saw that in a case called Cooper versus Aaron, when the governor of Arkansas said he was not going to comply with Brown versus Board of Education, and the U.S. Supreme Court said, yes, you are. Yes, you will. And ultimately, the governor did comply, and we had the Little Rock 9. All of that's mentioned down below in your notes. One of my excellent students, after studying so many materials, she said to me, the court seems to have great power. Are there any limitations on the court? And I said to her, of course there are. And that is the subject of our next video. Make sure you watch the follow-up one, which will talk about limitations on the court's power of judicial review. There has to be some limitations. Otherwise, remember, power corrupts, and absolute power can corrupt absolutely. This is a taste of justice with Professor Angela May Kupenda. See you soon. Thanks.